Hello, everyone. My name is Amanda Bridenstine, and I'm an estate planning and elder law attorney. We're going to talk about, my practice area today. If you, one thing, if looks like everyone, okay, it looks like everyone is muted. Never mind. If you're not muted, you may want to mute yourself just so there's no background noise. Okay, so I am an attorney with Cleaver and Sokolowski. We are one of the elder law firms in Stark County. There's only a few. There's only about 3, and we're one of them. And we help families with estate planning, which is preparing wills, trusts, and powers of attorney. And not just preparing documentation, but really making sure that you have a plan in place, and we'll talk about that. And then we also help families with probate and estate administration. When a loved one passes away, how are we going to transfer assets and tidy things up so that that deceased person's affairs are handled? And then we also do, more specific to elder law, we do Medicaid planning. When a loved one needs to go into a nursing home, we help the family plan to get the person qualified for Medicaid and protect a portion of the person's assets so that they don't go broke in their final illness, which is what happens to many people when they don't work with an attorney. And then we also just help families on a wide assortment of elder law issues, issues with Medicare, with Social Security. Many families don't have to worry about Medicaid per se, but maybe they need help and advice and counsel on independent living or assisted living, or an issue that they're having with providing care, or maybe VA benefits or something like that. So you'll see in the bottom left, that's my phone number and address, contact information. So feel free to write that down if you like. And we can go to the next slide. Okay, so this slide is just kind of the high points of what we will be talking about today. The big thing that we'll talk about is, do you have a plan? When we meet with clients, many clients call us saying, I need a will. And perhaps based on past experience, they think they're just going to come into the office, tell us who they want their executor to be and their beneficiaries. We'll type it up, have them sign it, and away they'll go. So we do things a little bit differently here at our office. We want to make sure that you have a plan to limit the costs of the administration of your affairs after you've passed away. We want to make sure that we limit the costs as much as possible so that your family can retain as much of your assets as possible as inheritance. And then we also want to make sure that we have a plan to make things easier on your loved ones. If the time comes that you become ill or you do pass away, we want to make sure that we have thought through things and have a holistic plan. And as I put here in the presentation, having a will does not necessarily equate to having, an actual plan in place. So when we meet with clients at our office, we do a full consultation, and we go through everything with you. We talk about what your family situation is like and your health, and what kind of assets do you own in your estate. And we ask some of those tough questions. We want to make sure that we do help you put a plan together. It's more than just estate planning and elder law. For us, it's more than just jotting down some information in a will form. So we'll also talk about the importance of naming an agent to make healthcare decisions, ensuring that your wishes are carried out upon your death, and then, as I mentioned earlier, making things easier for your loved ones. That's a big thing. I work with many families who have kind of a mess on their hands when the time comes, and that's unfortunate. So we try to work with people while they're still healthy and enjoying retirement, to make sure that if the time comes that they do become ill, that things are already tidied up in advance for their kids or their loved ones to take over. Okay, next slide. Okay, so the first thing that we want to talk about is a durable general power of attorney. In our office, we actually say that this is the most important legal document that you could have from an estate planning perspective. We think that this is actually more important than having a will, because this is the document that enables your loved ones to manage your finances and your non-medical decision affairs. If you're still living, but you're either having major health issues, or you're very old and have had perhaps a decline cognitively, where you're just not able to manage the full breadth of your affairs anymore. This is very important, and not just to have a power of attorney, but to have a modern power of attorney that has all of the important provisions in it that are necessary in today's day and age. So as this says, a durable general power of attorney enables someone to make financial decisions for you. You have to execute, which means sign. You have to sign a POA while you're still of sound mind. And that's something that we run into occasionally, is that a family comes to us when mom or dad has declined cognitively to the point where they're not competent. And then the family wants us to go ahead and sign the POA. Well, we can't do that. So it's important, if you don't have a power of attorney, it's important that you get one while you're still doing well. The other important thing is that this avoids guardianship through the court. So if you have a health crisis or experience dementia or cognitive decline, and you don't have a POA, and if your family does end up having to manage your affairs, then they have to go to the probate court, to Judge Park, and they have to ask the court to appoint them, or to appoint your loved one to manage your affairs. Well, there's lots of problems with that. We'll go over that a little more in a future slide. But guardianship is very cumbersome, and it's costly in attorney fees. So we want to avoid it as much as possible, and that's really the big reason why we suggest you do a power of attorney. Is there's two lanes. Either you're going to have a power of attorney or you're going to have a guardianship. It's always a better idea to have a power of attorney. Something to keep in mind: a power of attorney is very powerful. It is most commonly, we draft them that they are effective upon signing. That means that the day you sign the document, if you were to hand out originals, if you sign that in triplicate and you hand out originals to your family members, theoretically they could take that and use it that same day for better or worse. So you want to know when you're signing a power of attorney, is it effective upon signing, or does it have a special springing clause in it so that it only becomes effective upon incapacity? That might sound great, actually, having a POA that only becomes effective upon incapacity. The problem with that, though, is that if you are experiencing health issues and let's say your kids or your loved ones already have all of the challenges of trying to manage your physical care and manage your finances in every part of your life, and then now on top of that, to be able to use the power of attorney, they're going to have to get your doctor to certify that you're incapacitated. And that can take several weeks or months for the doctor to get around to do that, or maybe the doctor doesn't want to do it. We've seen issues with that. So generally in our office, we make POAs effective upon signing, and then we just encourage you to keep it in a safe place at home and don't give out copies. And then something else to keep in mind, some of you may have a power of attorney right now, but sometimes I meet with clients and they have a very basic power of attorney that doesn't actually have the provisions in it that are necessary to do business in the modern world. So in our powers of attorney, because we're elder law attorneys, and we really try to be very good and very diligent in this practice of law, we have some pretty beefy POAs that we use for our clients. They don't just have the general language that enables you to manage affairs or to do bank accounts, but we include other beefier provisions that deal with electronic assets. Electronic assets are email, social media, and any website you use where you have a login. What we've seen sometimes is that there's a very good reason why when you're incapacitated, your family needs to access one of your online accounts. Well, if you don't have a power of attorney that specifically authorizes them to access your electronic assets, that company most likely is not going to allow them to do that. They're gonna, if they don't know what the password is, they're gonna be locked out. And if the family needs that because they need to access some financial information, that can be a real problem. Also, it's very important that your power of attorney specifically mention IRA accounts or individual retirement accounts, some wording that specifically deals with IRAs. Many general POAs will say that my agent has the authority to manage my investments or my finances. It'll have some general language, but companies that that manage IRAs, so let's say, you know, Fidelity or Charles Schwab or whatever company that you use, they want to see IRA language in your power of attorney. And if they don't, it's a problem. And I've had families that I've worked with who have come into problems where their loved one is incompetent and we can't sign a new OPOA, and they have a general POA that a general attorney that kind of practices general law executed for them at some point, and it doesn't have that IRA language in it, and then the family cannot access the IRA to pay bills. It's a problem. Something else, Medicaid planning. You want a power of attorney that has special provisions in it that enable your family to do Medicaid planning. So for many of my clients, they live their whole lives and they never have to go to the nursing home, or they just never need Medicaid planning, and that's great. But if you do end up being in the position where your family is looking at a long stay in a nursing home and your family doesn't want you to spend down your whole life savings in the nursing home, the only way your family can hire an attorney on your behalf to do Medicaid planning is if your power of attorney specifically has the specific provisions in it that authorizes them to do the different components of the Medicaid planning. Okay, next slide. We talked about that, so we can skip that. Guardianship. So this is what happens, as I mentioned, if you don't have a power of attorney that you signed while you were still in good health, you know, with a sound mind, and if your family needs to manage your affairs, they will go to the probate court. They'll ask, if you live in Stark County, they'll ask Judge Park to appoint one of your loved ones as your guardian, and you will become the ward. So the problem with guardianship is that every single financial decision has to be pre-approved by the court. And that includes trips to the grocery store, you know, trips to buy toiletries, clean underwear, whatever it is, you name it. The court has to pre-approve that. And we as attorneys know how to get that done in a manageable way, but many families don't. Or even if we do say this is the framework for how we have to get grocery trips pre-approved, oftentimes we see that families don't do it the right way, and then that upsets the court, and then we end up having to go see the judge or the magistrate. Very expensive in attorney fees, can be several $1,000s in attorney fees, especially if the family isn't really following along with the court's procedures. And also your guardian has to be a resident of Ohio. So if you have a child or a niece or nephew that lives out of Ohio, but is otherwise capable of managing your affairs, you know, in this day and age, a power of attorney with a son or a daughter in Florida is no problem because you can pretty much manage everything electronically. With a guardianship, you have to live in Ohio. Also, you have to be bonded by an insurance company. The guardian has to take out an annual policy, and the policy says if the guardian steals from you, the insurance policy will pay back. Well, that insurance policy can be, you know, $1,000 a year or more. It just adds to the expense. So again, we encourage our clients to do a financial power of attorney. Also, if you could mute yourself if you're not muted, I would appreciate that. Okay, next slide. Healthcare power of attorney. So this is the document where you designate your loved ones, a spouse or children or a friend, to make healthcare decisions for you in the case of an emergency. A healthcare power of attorney only comes into play if you are incapacitated, that it says it in the on the first page of the state of Ohio form. So this is also very important. Healthcare power of attorney also has a HIPAA release in it. So if you're married, just by way of being married, part of the benefit of being married in the state of Ohio is that you automatically get to make healthcare decisions on behalf of your spouse, you know, in the case of an emergency. However, just by way of being married, you do not have the right to receive HIPAA protected health information. So HIPAA, many of you probably have heard that term before, but that's the body of law that says that our private healthcare information stays private even amongst our family members unless I have signed a HIPAA release authorizing my physicians to release that information to the specific people that I designate. So just by way of being married, you don't automatically have a right to HIPAA information. So the problem that can create is that maybe the doctors will let your spouse make healthcare decisions for you, but they may be, there's certain types of information that they may be hesitant about sharing with even your spouse. And certainly for children or other, if you just have other loved ones or friends that you want to make decisions for you, not only is it important that you designate them in a power of attorney so that the hospital and your physicians know what your wishes are, also so that you can designate what is the contact information for my spouse or my children. The healthcare power of attorney says it right in there. In the case of an emergency, call this phone number and ask for Carol, you know. But also our healthcare power of attorney has a HIPAA release in it so that your physicians are on notice that any protected healthcare information that your family or your friends would need to know in an emergency in order to make an informed decision, that it's okay that they share that. Next slide. Okay. So a living will, this goes along with the healthcare power of attorney. And this says that if you are terminally ill or permanently unconscious, that you are authorizing your physician to allow you to die naturally, providing you only with comfort care. This is only for end of life decisions. And the standard in the document is actually terminal illness or being permanently unconscious. It expresses that you don't want extraordinary measures. It authorizes your physician at that time to issue a do not resuscitate or a DNR order. It doesn't include a DNR order because most people, even if you're at an advanced age, if you're in good health, you know, you still may not want to have a DNR. You know, many people, even at an older age, I would think if they go into cardiac arrest, could still be revived and recover. But so this is for people that are terminally ill or permanently unconscious. There's a clause in the living will that at that point, once that determination has been made, then gives your physician the authority to make a decision about issuing a DNR order. Because if someone's terminally ill, then it probably doesn't make sense to resuscitate them if they go into cardiac arrest. It allows your agents to refuse feeding tubes. It refers to it as the provision of artificial nutrition and hydration. It does take precedence over the healthcare power of attorney. However, a healthcare power of attorney has a section that overlaps with the living will that authorizes your healthcare POA to make decisions about life support if your living will cannot be located. And the thing that I like to stress with a living will, and specifically the section that talks about life support, just because someone's on life support doesn't mean that they're going to die. The whole point of life support, from my perspective, is that it's supposed to take some of the stress off of your body so that you can recover. So in the section that talks about that says, I authorize my agent to make decisions. Your agent is your representative. I think that, you know, if you have a living will or if you're going to, you know, get one after this talk, I encourage you to discuss with your family what your wishes are. because I don't like my clients to sign a living will thinking that if I go on life support, I just automatically want my my family members to pull the plug, as I frequently hear in my office. I think you want to tell your family members that they need to do what they feel is best. I was in a situation where I was the representative for someone who is on life support, and we were dealing with the living will, and I didn't feel that it was the right time to remove the life support, even though I was invited to do that by hospital staff, and the person ended up coming out of a coma-like state. And ended up becoming fully conscious, and it was like a miracle in the moment. So I always encourage my clients with a living will, you're authorizing more so than authorizing your agents to pull the plug. You're authorizing your agents to make the best possible decision for you, because your loved ones are going to be in your corner more than anyone else. Okay, next slide. Okay. So let's talk about, I like to call it legacy planning. I think that's a nicer way of saying it, and I think that it expresses the heart behind why do we do wills and trusts. It's because you want to leave, a legacy for your family and your loved ones, or whatever charitable organizations that are important to you. So there's a couple of different ways to dispose of your assets upon death. Probably the most common way that everyone knows about is a will. I like to think of it as a safety net. In the type of estate planning we do in our office, we do think of a will as a safety net, and I'll talk about that a little bit more in a moment. Then there's a trust. We'll talk about trusts also. You want to make sure, if you have a trust, that it's properly funded. I meet with a lot of people who have a trust from 20 years ago, and they don't have anything in it. And then what was the point of that? If you got the trust to make sure you avoid probate in the probate court, but you don't have any of your assets in the trust, then you're not going to avoid probate. And then beneficiary designations, having a survivorship deed, having a TOD, which is a transfer on death affidavit on your house. You can TOD or transfer on death financial accounts, and then a POD is on bank accounts. You can name a beneficiary in your bank accounts, and then the bank will pay out or pay on death that account once you've passed away. Okay, next slide. Okay, a last will and testament. A last will and testament, also called a will, it names an executor to gather your assets, sell them, pay debts, distribute proceeds, pay your taxes, that type of thing. The will says who you want your beneficiaries to be and how much do you want them to get. A will does not avoid probate. Many people that I meet with are confused about this. They think that because they have a will, they're going to avoid probate. So what is probate? Probate is the court-administered process by which your assets are gathered in. The probate court supervises your executor gathering assets and then distributing them out to the beneficiaries, and then the executor has to give a final account to the judge on what was done. The problem with probate is that it's expensive. Attorneys in Stark County are allowed to take a percentage of the value of your estate as their fee, and in this office we do that. That's what the local rule prescribes. So that's what we do. It's also can be timely. It's anywhere from 6 months to 2 years. That's how long a full probate administration takes, and it's public record. So your personal information is available. Some of it is available right on the court's website, and then some of it is available if anyone just wants to go downtown. So most people want to avoid probate if they can, except for some rare scenarios. Sometimes with fighting children, sometimes it is better for things to be probated. But by and large, most clients want to avoid probate. So the will is actually your direct ticket to the probate court if your will is the primary component of your estate plan, because it's the instructions to the probate court on who's to be your representative and who you want your beneficiaries to be. So in our office, I like to think of a will as a safety net, because in our office, what we do is we say that the primary component of your estate plan should either be a trust or beneficiary designations, where on each of your accounts you're designating your different loved ones to be your beneficiary. And then we like to think of the will as the safety net down below, that if we missed a couple things, or we missed one thing here or there, then at least we have limited, hopefully we've limited your probate estate to a small probate administration, which is less costly in attorney fees, less costly in court costs, and it's quicker. Or also if you, I have a client who received a personal injury settlement and didn't get the money until after she died. So we used her will for that. Something else that an important reason to have a will is for the unexpected. Like if you get a lawsuit settlement, personal injury settlement that at the time that you were setting up your estate plan, you didn't expect to receive, but later on down the road, that's an important reason to have a will. And then also for digital assets. So I mentioned that earlier with the power of attorney. If your family needs to access your digital assets, your online accounts, online assets, after you've passed away, the only way they can do that is if your will specifically mentions digital assets. So I met with someone recently who had beneficiary designations on all of her accounts, so she didn't think she needed a will. So we talked through it. In this office, we always recommend that you have a will as a safety net, even if you have beneficiary designations, for those reasons, for digital assets, and then also for the unexpected. Very important. Okay, next slide. A trust. So a trust, for the most part, most of the time when we're talking about a trust, we're referring to a family revocable trust that mainly deals with avoiding probate. A trust, it designates who your representative is, similar to a will. We call that the trustee. During your lifetime, you are the trustee, and then you name someone to be the trustee after you've passed away. And then the trust also designates who you want your beneficiaries to be and how much. A trust is, it's a legal document, but then it also sort of becomes like a legal entity at the same time. It can own property. However, a family revocable trust is flow through from a tax perspective. During your lifetime, you don't have to get a separate tax ID, so you don't have to do a separate tax return. We encourage trusts to avoid probate for people who have a sizable estate, probably $500,000 or more in total assets, and or if you have lots of different accounts. And rather than maybe just having 2 or 3 accounts that are all streamlined, if you have money in lots of different places, a great way of making sure that everything avoids probate and that nothing falls through the cracks is to have a trust. Also with the trust, we can hold inheritance in trust for children or grandchildren. If you have, if you don't want your grandkids on their 18th birthday to receive a windfall of inheritance, a trust is a great option. I say that because many times people will say, I want my estate to go to my child, but if my child predeceases me, I want my estate then to go to my child's child or my grandchild. So then when we crunch the numbers, if it looks like a grandchild could inherit, let's say $100,000, do you want them to have access to $100,000 on their 18th birthday? Most people say, oh, no, I don't. So the way then that we protect grandchildren from themselves to make sure they don't receive inheritance till they're a little more mature is that we set up a trust, and then within the trust we do a grandchild trust, and we say that grandchildren can receive their inheritance in increments, usually up till the age of 35. We also, if someone has a child with special needs, or a child that has dependency issues or whatever, we can put a provision build a provision into the trust that holds their money in trust, so that they don't lose access to any government benefits that are really helping them. And then, as I mentioned earlier, if you have a trust, you want to make sure that it's funded. That's important. We don't ever want to set someone up with a trust that never gets funded, because then that was a waste of a couple $1,000s. Okay, next slide. Okay, so this slide talks about beneficiary designations. This is where you are filling out the paperwork, either at the bank or with Charles Schwab or Edward Jones or whoever, um, where you're filling out the paperwork to add your loved ones as beneficiaries. This most oftentimes is for people that don't have a trust. And with a beneficiary designation, you know, you can't hold it in trust. It just says, on my death, pay this much of my account outright to the person that I'm naming. We use these on real estate. You may or may not know this, but we can put a beneficiary designation on your real estate so that when you and your spouse have both passed away, that your house avoids having to be probated. So that is often a huge savings for families to avoid probating the house once both mom and dad have passed on. We can also do beneficiary designations, like I mentioned, on bank and investment accounts, on life insurance, retirement accounts, on vehicles also. You can add a beneficiary to a vehicle title. Okay, next slide. Okay. Oh, you know what? Can we go back to the previous slide? Thank you. Okay. The one thing I wanted to mention is that if you have annuities, you just want to ask questions about your beneficiary designations. I did have some clients who had filled out the beneficiary paperwork for several annuities, and it was a husband and wife. They bought the annuities together, and they said, you know, we're co-owners, and then when we both pass away, we want it to go to our 2 children. So the annuity company, it was actually several different annuity companies, what they all said was that the wife, who was the co-owner, was actually the primary beneficiary, and then the kids were backup beneficiaries. And the long story short was then all of those annuities ended up having to be probated. So that's one reason why I say when someone has several different assets, sometimes it's just easier to do a trust. Because if the asset is owned by a trust, we know it's going to avoid probate. Sometimes these companies play games with how they deal with their beneficiary designations, and it's, to me, I've noticed it, you know, the most with annuities. So that's just something to keep in mind. Okay, next slide. Okay, how do I protect assets? So protect assets from what? So here we're talking about protecting assets from a nursing home spend down. So that's when we're talking about asset protection, most often that's what we mean. So doing asset protection depends on the health of the family members and the amounts and types of assets. That's so true. So normally when we do asset protection, we're going to set up a trust, but it's a different type of trust from what we were just talking about. It's an irrevocable trust. The owner of the trust has less access to it, and there's limited changes they can make to the trust once they've set it up. So it's not ideal for everyone. It's really just for people that are really motivated during their healthy retirement years to do planning to protect their assets ahead of time in case of a nursing home crisis. And like I said, when we would start that planning, whether we would start that planning when you're 65 or 70 or 75 or 80, you know, it depends on your health. For many clients, if you have some health problems and you're concerned that you may not, you know, make it as long as you would like before you have to go in the nursing home, then we might want to start that closer to 70 doing asset protection planning. But if you're someone that has longevity in your family and you come to me at the age of 83 and you've decided you want to do asset protection and your parents both lived into their mid-90s, then that's no problem. The thing to keep in mind though is that when we're doing asset protection, there is a 5-year look back. So for the planning that we do to work, we have to do it 5 years in advance of you needing care in a nursing home. So that's why I say that we want to keep in mind what your health is and what type of assets you have. Also, you know, real estate like your house, that's very straightforward to put that into an irrevocable trust. IRAs are not so straightforward. So sometimes what we'll do for families is that we'll set up an irrevocable trust, and maybe we'll just put in the house and some money in a bank account, but then maybe everything else will stay out of the trust. And what at least that does is, if you ever do need a nursing home, it limits the amount of money at that point that we're having to do the emergency Medicaid planning on. So there are some things that are available. The Veterans Administration offers a pension called the VA Aid in Attendance. And if your assets are below $127,000, then you qualify if you need care either at home or in a facility. Sorry, the dentist office was calling me. If you're a veteran or the spouse of a veteran, and if you served in a foreign war, so World War II, Korea, or Vietnam, you didn't have to serve in country, but if you served active duty during one of those wartime periods, if you were the veteran, or if you're the spouse or widow of a veteran, and if you qualify financially as stated on the slide, then you may be eligible for a pension, the VA Aid in Attendance pension, that will help pay. Usually it helps to pay for assisted living or in-home care. Medicaid benefits, they're a little more complicated. If you are a single person, basically you have to spend down until you have $2,000 left in a single checking account. So that means that if you, in your latter years, let's say you have $200,000 or $300,000 in your total estate, and now you need the nursing home, and you're going to be there maybe for a couple of years, you're going to pay $8,000 a month, or whatever the monthly cost is. You're going to pay that out of pocket every month. And then finally, when you only have $2,000 left in your total estate, then Medicaid will kick in. If you're a married couple, and let's say one spouse is healthy and living at home, and one spouse is sick and needs to go into the nursing home, Medicaid will let the healthy spouse keep the lesser of half the estate, or $126,000. And actually, I think that number recently changed. But so if you have a $400,000 estate as a married couple, that's a significant amount of money that you have to spend down in order to qualify for Medicaid. And basically that's why families work with us. We do pre-Medicaid planning, which is where we set up the trust while you're still healthy, and we protect some assets ahead of time. And then we do emergency Medicaid planning, or sometimes it's called crisis planning. And that's where right at the time that you or your loved one needs to go in the nursing home, right at that point, we as an attorney can do planning to get you qualified for Medicaid and protect half of your estate, or for a married couple, half of the amount that Medicaid says that, says has to be spent down. So we do a lot of that. Actually, we're one of the only law firms in Stark County that does that type of planning. And for families that that are experiencing a crisis like that, it's very important, especially for married couples. You want to make sure that your spouse that's still healthy and at home has a nice nest egg. Everything that you've saved for, we want to make sure that we can conserve that, so that your spouse that's living at home doesn't feel extra stress on top of everything else by having to pinch pennies. Okay, next slide. Oh, you know what? I'm sorry. Can we go back to the previous slide? There was one thing I missed. Okay. The bottom point. Make sure your power of attorney includes the proper language. So I mentioned that earlier when we went over a durable general power of attorney. You want to make sure, if you have a power of attorney, you want to make sure that it mentions the proper Medicaid language. You by reading the face of your POA, you may not be able to pick out what is the proper Medicaid language. If you're not an elder law attorney, it's probably not evident to you. But when I meet with clients at my office, when they bring in their existing estate planning documents, we always read through what they have. If their POA has all the language in it, we're not going to have them redo their POA. But if their power of attorney doesn't have the Medicaid language in it, or the IRA language, then we're going to advise them that they need to update their power of attorney so that it has that important information in it. Okay, next slide. Okay. So there's some important things to think about with dealing with long-term care. We counsel clients frequently on what kind of care is appropriate. Is in-home care appropriate? Many people do well with having, home instead or a similar agency coming in for a couple hours a day just to help with some light cleaning and meal prep and bathing or laundry, whatever. Some people do really well with that. However, some people, they need the social interaction, being homebound, they miss out on all the social interaction, and then that actually contributes further to the cognitive decline. So some people actually thrive in assisted living because not only are all of their care needs met, but now they have the bustling social life that they previously had, or for some people, maybe they never had a bustling social life, but even just being able to sit with people of similar age, similar experience, being able to sit with them for every meal, in the dining room really, really helps cognitively. That's what my experience has been. And I've found that there's lots of misunderstanding in the community. People think that assisted living is bad or that it's like a nursing home. It's not. Most assisted livings are lovely. We do counsel clients, though, as elder law attorneys. We do counsel them on what are the good facilities, and that's also something to keep in mind. Sometimes a family will walk into a facility and it's brand new and it's beautiful, and they think, oh, this is great. But maybe they don't know that some facilities have a better reputation than others for providing good care. And so that's something, that's another reason why we think it's important. If a family is milling over these really weighty decisions, it's important to talk to an elder law attorney in your community. So not an elder law attorney that's up in Lorraine or in Columbus, but an elder law attorney in the community where you live who has relationships with the facilities and who can advise you on what are the things that you need to consider when you're making a decision about where is mom or dad going to live next, but also what is that facility's reputation in the community amongst the elder law community. Assisted living with memory care, generally not eligible for Medicaid benefits. Sometimes there's confusion with that. Most assisted livings actually do not accept Medicaid. That also is something we've frequently met with clients who have said, well, this facility told me that when mom or dad runs out of money that they would let them go on Medicaid. But then that, when push comes to shove, isn't always the case. And again, we as elder law attorneys here in the community, we know, what's what with those types of marketing ploys. And then, I think this is the last slide. The last thing to mention, as far as how do we deal with paying for care, planning ahead is very important. What if we didn't plan ahead? Again, that's where the emergency Medicaid planning comes into play. Even if you haven't done any planning ahead of time, most people don't actually. We're still able to get people qualified for Medicaid and protect a portion of the estate that they've worked so hard to build. And then, as I mentioned previously, great importance in having a good power of attorney. So.
Thank you, Amanda.
Absolutely, my pleasure. Thank you all.